According to the plea bargain agreement, punishments be assessed at a cap of 7 years. There are no applications for deferred. State opposes community supervision, and there are other cases that are being taken in consideration.
Welcome to the Court of Justice.
Is calling 2022 CR 1102, State of Texas versus James Lee Lawrence. Could I have parties announced for the record for the state?
Brian Groomer for the state of Texas.
For the defense?
George Sharman on behalf of Mr. Lawrence.
And are you Mr. Lawrence?
Yes, Your Honor.
All right, we are here for sentencing. You entered a plea on August 31st. You entered a plea of guilty. You applied for probation. According to the plea bargain agreement, punishments be assessed at a cap of 7 years. There are no applications for deferred. State opposes community supervision, and there are other cases that are being taken in consideration. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
Yes, Your Honor.
All right. Are there any witnesses, State?
None from the state, Judge.
Defense?
Just my client.
All right. Any objections to the PSI report? State?
None from the state.
Defense?
Not really, Judge, but my client does have one comment about it when it talks about employment.
Okay. All right. You want to call your client?
Right here, the defense begins laying the groundwork for probation. And notice the strategy. They're not just asking for leniency. They're framing Lawrence as someone who's already taken steps toward rehabilitation, mentioning drug court, showing enthusiasm, presenting him as cooperative. It's all designed to signal to the judge, this man is fixable. But here's the catch. Judges don't just look at what you say you'll do. They look at what you've already done. And in cases involving repeat DWIs, the court is especially cautious. So as you're watching this, ask yourself, would you be convinced by this approach so far? Or are you already wondering what's coming next in his record?
Yes, Your Honor.
All right. If you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand if you state your name for the record.
James Lee Lawrence.
All right. Defense?
Mr. Lawrence, first of all, are you asking the judge to give you probation?
Yes, Your Honor.
And have you talked to the people over at the drug court?
I did meet with representative from the drug court. I was not knowing what to expect, but I was very impressed, really excited about the opportunity.
Is that if the judge grants you probation, is that a program that you think you could get behind, that you could do and be successful with?
Without doubt.
The problem that you had was, as part of work goes, that you had a business of your own.
I have owned my own company for 20 years.
And what was that? Or what is it?
We're outdoor living and pool construction company.
What happened with that business now?
Right now, my 24-year-old son, which has been my project manager, is having to step in and facilitate operations, sales, and all the back-end work in addition to managing construction. Pretty difficult.
If the judge chooses to give you probation, is that the line of work that you would like to continue with?
Yes, it's family legacy.
And that's for your son?
Yes.
Would you tell the judge, you have some things to tell the judge yourself?
Yes, if I may, Judge.
Mhm.
Judge Court.
Yes.
I'm a little nervous, so I want some notes.
Okay.
I wanted to request that the court agree to the sentencing of a drug court, probation, and outpatient in the rehab program.
Okay. Let me stop you right there.
And there it is, the turning point. The judge immediately shuts down the idea of outpatient treatment. That's not just a minor correction. That's a hard line. What she's essentially saying is, based on your history, I don't trust a less restrictive option. In legal terms, this reflects judicial discretion shaped by risk assessment. When someone has repeated substance-related offenses, especially involving public safety like DWIs, courts often escalate interventions, meaning inpatient treatment or structure programs become a baseline. This moment tells you everything about how the judge is leaning. So now the question becomes, can Lawrence recover from this setback, or has the direction of this case already been decided?
Yes, sir.
So here's the thing. I'm looking at your history. I know that the state has selected your punishment be at a cap of 7 years, and I know that the state is opposed. So I'm telling you, based upon your criminal history with alcohol and everything else that's going on in your life, if I were to give you probation, you are either going to be in felony drug court or either you're going into inpatient treatment. So there's not going to be outpatient treatment from this court. So we need to take that off the table and that request off the table because that's not going to happen. Okay. All right.
Well, because just in retrospect to exactly what you said, my criminal history is, in my opinion, a two-phase history. If you look at my history,
It's a lot of DWIs. That's why we're here. You won't stop drinking and driving.
Exactly. DWIs is all that it has been, with the exception of prostitution and driving while license suspended, I believe, and like that. And I would present to you that, in those three DWIs in 1991, I was 21 years old. I had I felt like an entitled person. I was playing football in college and didn't respect authority, and I felt entitled. And when I got in trouble, I still felt like I was in this until I started having children. I started having children in 94. And I realized that I needed to become a man and support my family, but take care of my children. And I did that. I raised 4 wonderful children. My oldest has a master's degree. My second child has a bachelor's degree. My third child is working on his bachelor's. And then my son has graduated from construction career and manages.
Okay. And sometimes that happens in spite of, not because of. You understand?
Well, my point was that I was getting to the second phase is during that 30-year time period. I never was in court at all. Never got arrested. Never got DWI. As a matter of fact, I didn't drink for 15 years. I was really devoted to the church, actually. The last 5 years have been tough. That's where the change has come.
How's it been tough for you?
I got divorced in 2021. The divorce finalized in August of 2021. It was tough for me. We were together for 29 years, and I still have not healed from it. It's mentally, I don't know how to answer the demons that I feel. And it's not necessarily demons, but on a daily basis, I'm waking up with anxiety and just things going on in my head that I can't answer. And I've tried to figure out what I can do to release. I felt like I was in prison in my own body.
This is the emotional core of the defense, and it's powerful. Lawrence paints a picture of personal collapse, divorce after nearly 3 decades, anxiety, mental struggle, and a sense of losing control. And to be fair, courts do consider mitigating circumstances like mental health and life stressors. But here's the legal tension: explanation versus excuse. Judges are trained to separate the two. While his story adds context, it doesn't erase the risk he poses when he gets behind the wheel intoxicated. So here's something to think about. How much weight should personal hardship carry when the consequences could endanger others on the road?
And so the day of that arrest, I remember specifically waking up that morning. My phone line started ringing from my business, and I got really anxious. I called my assistant and I said, "Look, I can't work today. I don't feel right. Something's wrong." And I'd been having these anxiety attacks for probably the last 6 months. My wife had remarried a month after the divorce was finalized. And so that day, I had one of my subcontractors call me and say he needed me to come on job site, and I had planned on not working because I was feeling really bad. And when I made the decision to go out and visit with him, the stress from what he had presented was tough, and I drank. DWI.
Okay.
Third offense. I acknowledge that I've had a problem with drinking and other addictions, and I need help. Prison is not a help for me. I will complete prison if that's what you sentence me to. But I do need some type of rehab help. And the reason I've asked for outpatient is because I really do need to help run the business. Otherwise, we won't have that to continue on. That's why I'm asking. And then lastly, to be honest with you, Judge, whatever you sentence, I'll be back here. I won't be back in an orange uniform. I'll be back as a testimony.
All right. Thank you very much. State, any questions?
Briefly, Judge. Mr. Lawrence, and the judge does have this, but back in 2017, you were put on probation for DWI third, correct?
Correct.
And in 2018, you picked up a new case while on probation for DWI third or more. Is that correct? A prostitution case?
It was, yes.
Okay.
I'm not quite sure if that was the final judgment. There was a no contest plea.
All right. But you were convicted and sentenced to jail for 30 days on what I have as a prostitution case. And that was while you were on probation for DWI third or more, correct?
Sure.
And you finished your probation in March of 2021 on that case, correct?
I finished it with flying colors, no bad tests. I completed all my classes. I paid off my fines. Never was late for reporting. Yes, I did complete.
Okay.
And then a month later or so, somewhere within that time frame, again around the same time frame, with my issues with my ex-wife, I received another DWI. That's where you're going.
I am. And with flying colors, you did pick up a new case. So you didn't pass it with flying colors. I mean, you committed new crimes while you were on for that first DWI third, right?
I don't, even you have to.
The
restate
prostitution
everything.
case.
You have to restate everything because I'm not following.
Okay. You said you passed your DWI third or more with flying colors. You picked up a new prostitution case while you were on that probation. So it wasn't with flying colors. You picked up a crime, correct?
I did pick up the crime.
Okay. And like you said, later in 2021, you picked up a new DWI third, and that's the case you're pleading to today, correct?
Yes.
Okay. And that's the case where here you crashed into the back of a car. You were twice the legal limit, correct?
I don't know what the blood alcohol was, but I do remember what happened. I bumped the back of a car, no nicks, no scratches. The gentleman was very young. We spoke about it.
All right, let's not minimize this.
Right.
I'm not. And then I told him, I said, look, if you're feeling bad, let's just go ahead and file a police report. And I saw police officers at the, I believe it was Denny's. And I said, let's just drive over there. And I contacted them personally. I did.
Okay. But you knew at that time, you'd already just came off probation for DWI third or more. You knew
I wasn't considering that.
Okay. So you weren't
I was
considering,
considering that young man.
all right, but you were
And I was
drinking
trying to
while
be
driving,
honest.
correct? That's
All
the
right,
case
so
you're
so it
pleading
has to be one at a time, okay?
I just feel like he was attacking.
Actually, I'm not attacking you. You're trying to tell the judge that you're a good candidate for probation. And I want to just make sure we have everything in context. So you know you're not supposed to be driving while drinking, correct?
Yes.
And at that time, you were arrested for this offense and you were released on bond, correct?
Yes.
And this could have been an opportunity for you to show the judge that you would be a good candidate
That
for
is
probation, correct?
That is correct.
And were your conditions while you were released on bond not to drink alcohol?
Yes.
And were they not to drive any vehicle that was not equipped with a alcohol monitoring device, correct?
Yes.
And
I think-
isn't it true that on July 28th of this year, you were arrested again for driving while intoxicated in another vehicle, a BMW vehicle that we didn't know about?
Yes.
This cross-examination is absolutely devastating and very calculated. The prosecutor isn't yelling, isn't being aggressive. They're methodically dismantling the defense narrative. Step by step, they show a pattern. Probation violated, new charges picked up, and most critically, another DWI while already out on bond. That last point, That's huge. In the court's eyes, bond conditions are a test of trust. Break them, and you signal that supervision doesn't work on you. Legally speaking, this is one of the strongest arguments against probation. So now ask yourself, after hearing this, is there any realistic path left for the judge to justify giving him another chance?
So is it fair to say that you didn't follow the conditions of your pretrial release, even on the case that we're pleading to right now?
It's fair to say that I was driving. I haven't been convicted of that, but I was driving the vehicle and.
Well, it's being taken into consideration in this plea.
Oh, okay.
So are you admitting that you did drive intoxicated again on July 28th of 2022?
Am I admitting that I drove intoxicated?
Correct. I think part of this is the judge wants to see what you're accepting responsibility for.
Yes.
You would agree that that shows the judge that she gave you conditions as a matter of this bond and you did not fulfill those conditions,
I
correct?
did not feel it.
I'll pass the witness, Your Honor.
No further questions.
All right. So, Mr. Lauren,
Yes, sir.
what I'm going to tell you is I was thinking long and hard about giving you probation because I realize that you do need the help.
I did.
But my issue is that you're on bond and there are conditions for bond. And at any time, and I think everybody knows, anybody who comes in here, if they need help with drug problem, alcohol problem, if there's something with pretrial services that can help them with their issues, I like to get them their issues because my goal is I don't want to see people back here before, again, picking up new cases. I'm hoping that everybody is going to be successful.
I understand.
So I am not going to grant your application. So now we need to speak.
And just like that, the decision is made. The judge explicitly states she was considering probation, but the bond violation changed everything. This is a textbook example of how last-minute conduct can completely alter sentencing outcomes. Even if someone presents well in court, their actions outside the courtroom speak louder. The prosecution then reinforces the danger argument, highlighting that repeated drunk driving isn't just a personal issue, it's a public safety threat. At this point, the courtroom dynamic has shifted from rehabilitation versus punishment to risk versus protection. And when that happens, prison time becomes far more likely.
Towards the cap, and the cap is for 7 years. State, what are you requesting?
Judge, we're requesting the cap. He was facing 2 to 10 years on this case, as well as a new DWI case, which, like you said, he picked up while he was on bond for this particular case. We believe that 7 is appropriate. He just recently came off of felony probation for the exact same offense. I think at this point, he's demonstrated himself to be a danger to others because he keeps letting his addiction let him get behind the wheel of a car and place others at risk. We would ask for 7 years.
All right, defense.
Judge, I would ask that you would consider putting him into a safe P program for 6 months, 9 months, whatever it is, and leave this open for probation after a successful completion of that. And that way,
He can't go to safety if he's not on probation.
that's what I'm saying. And I'm asking you to do that rather than just to send him to prison, to send him to safe P, which is, to some extent, it's a concrete building with a lot of other.
Oh, I know safety is at the prison. I've
And,
had clients who've
And it
gone
would
there.
be sort of like a shock probation situation.
All right. Mr. Lawrence, as previously stated, I'm finding you guilty. I'm going to sentence you to 7 years in the prison. Taking consideration grand jury number 77261, night mag number 672122. Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Good luck to you, Mr. Lawrence. Court is calling 2022 CR 4752, State of Texas versus Omar Kalunga. Could I have parties announced for the record for the state?
Brittany Sparks.
Defense?
Charles Buck from Mr. Kalunga.
And are you Mr. Kalunga?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, or did you review it with your client?
I have and we did.
Court will find that the state is in compliance with discovery. Mr. Kalunga, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding only on count one. We're going to waive count two as well as the enhancement paragraphs.
Any objection?
No objections.
Mr. Kalunga, I'm showing you what's entitled Court Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and is legally sane at the time of the offense?
Yes.
Mr. Kalunga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. This is to run concurrent with the Cameron County Cause number 2012 DCR 1795. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Then to the offense of, and count one, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence.
Yes, Judge. Stated, offer states exhibit one. All I have.
No objections.
Showing you what's entitled a waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
All right, the court will sentence you to 8 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with Cameron County case 2012 DCR 1795. And there's to be no contact with Jason Harmel, Harmel. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record.
Judge, the only thing on the ball, we're still on the record. He's
On the
been in
record?
continuous, yes, please. He's been in continuous custody since July 23rd of 2021. Some of that time was out of county, but I've given the clerk of your court paperwork, the documentation. I'd ask that the record reflect his credit begins on July 23rd of 2021.
All right, any objection, state?
No, Judge.
All right, it will reflect.
Okay, thank you.
All right. You need to do better. You understand? Otherwise, you're going to find yourself in and out of prisons, and you're going to look up and a majority of your life is going to be spent in prison. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, ma'am.
All right. Court is calling 2000.
James Lee Lawrence thought his tears would move Judge Stephanie Boyd. He spoke of anxiety, divorce, and 30 years of raising successful children. He admitted he had a drinking problem, but begged for outpatient treatment so he could keep his construction company alive. Judge Boyd wasn't moved. She pointed to his history, multiple DWIs dating back to 1991, a prostitution case while on probation, and most damning of all, a fresh DWI arrest just weeks ago, committed while he was out on bond for this very case. He violated the court's trust before sentencing even began. "You won't stop drinking and driving," the judge said flatly. The state asked for the full 7-year cap. The defense begged for a prison treatment program instead of raw prison time. But Judge Boyd had heard enough promises. "I am not going to grant your application for probation," she declared. She sentenced him to 7 years in the Texas Department of Criminal Justice. No deferred adjudication. No second chances. As bailiffs approached, she reminded him he waived his right to appeal. Then she looked at him one last time. "Good luck to you, Mr. Lawrence." But luck had nothing to do with it. For DWIs, a broken bond, a judge who refused to watch him kill someone on the road, James Lawrence walked out in handcuffs.